Today we are going to talk about patent linkage. The notion of patent linkage is not easy to define. It's something that links patent protection with the proceeding aiming to obtain a marketing authorization mainly in the pharmaceutical field. Now, in principle, the marketing authorization proceeding and a patent infringement and invalidity proceeding play on different levels. Sometimes the patent owner may think that the health authority should not grant a marketing authorization for an infringing product, which is fine as long as the patent is actually valid and infringed. The problem is that the health authority is not well equipped to evaluate patent validity and infringement. This is something courts do much better. And this is the reason for which, at least within the European Union, the principle is to keep the two issues separate, avoiding patent linkage. This principle has been lately established at the European level by the so-called Bolar Directive, which dates back to 2004. And this directive was actually enacted in Italy and ended up in our IP code. Italy, however, had his own particular story as far as protection of pharmaceutical products and mainly SPC is concerned, and for this reason we ended up with a particular provision which was provided in Article 68.1 bis of our IP code, according to which a party was not allowed to file for an MA authorization more than 1 year before the patent expiration, thereby introducing a sort of link between the patent, the existence of a patent, and the possibility and the timing of an MA proceeding. Now, this provision was criticized and ultimately led to a request by the European Commission in 2012, January 2012, to drop the provision itself, something which actually Italy did at the very beginning of 2012, cancelling the old Article 68.1 bis. However, in September 2012, the government decided to introduce a new piece of law by Law Decree number 158/2012, whereby the health authority is requested to revise the list of the pharmaceutical products which are reimbursed by our national health system, preventing from introducing in this list every medicinal product which is still patented. And this means that equivalent medicinal product will be actually out of the market until the end of the patent protection. And this can be seen as a new way to introduce patent linkage. And actually the new law was criticized and could well bring us again towards the authorities of the European Union. We do not know if this will happen anytime soon. The important thing to take in mind is that the new law exists and it plays a role in the battle between originators and generics. And we will keep you informed of any development, both on our blog, of course, and here on Lawyers Monday.